my live. This is Immigration Attorney Moumita Rahman. Thank you for joining me tonight. My name is Moumita Rahman and I'm an immigration attorney. I am here to answer your immigration questions and to say the questions that you may have on your mind. So if you are joining me for the first time, welcome to my live. I am live streaming on TikTok, Facebook, Instagram, and YouTube. I have been an immigration attorney for the past 14 years, and I believe that immigrants make America great already. So thank you for joining. Go ahead and let me know what country you're from, what state you're living in. I always love to see the diversity of my viewers, and to my clients who are watching, thank you for joining. It's nice to see you again. Hello to everybody. I hope everyone is having a great day. And I am going to talk to you about certain things that you need to know about your rights as an immigrant, especially if you are an immigrant who has worked for a toxic employer, who has worked for an abusive boss. If you have ever been in a situation where you have worked for someone here in the US and you are undocumented and you have received unfair treatment at work, not been paid for all the hours that you worked, not allowed to take a break, not allowed to leave the job premises, then these are things that you need to watch out for, and you need to understand that you may have the right to protect yourself in immigration and apply for something called a T visa. So let's talk about what are the circumstances under which you may have had a very bad time at work and what may qualify to help you get legal status in the US and be on your pathway to a green card without requiring the help of a US citizen relative, because let's face it, not everybody here has the benefit of being married to a US citizen or to a green card holder, nor does everybody have a 21-year-old child who can sponsor them. The majority of people do not have these connections, but almost every immigrant here in the US has worked for somebody. And if you have ever worked for somebody who has, let's talk about the scenarios under which your work situation may end up helping you qualify to get legal status in the US without having to leave. And by legal status, we're talking about protection against deportation, a work authorization, and a pathway to citizenship here in the US, okay? So if you have ever worked for an employer who has essentially exploited you in a really, really bad way, if your boss has been racist, makes remarks to you about immigration coming to get you, or they refuse to pay you for all of the hours that you work, if they scream at you, if they curse at you, if they generally make you afraid of what they might do, and even in some very extreme situations, your boss may have actually laid their hands on you if you've been sexually assaulted at work and your immigration status gets brought up to keep you quiet, to keep you accepting of these circumstances at work, then these are usually the symptoms of the sign of, basically they're the symptoms of a problem that is called trafficking in immigration law. And if you have been trafficked for the purpose of getting work out of you, forcing you to work, forcing you to provide labor, then this is usually a pathway to citizenship, okay? And I would love for everybody who's in the US, any immigrant, to know about this, because it is just a sort of miracle case, especially if you do not have a legal entry. If you entered the US illegally, then this may be an option for you. That does not require you to leave. If you have the permanent bar, you can also get that fixed through this case by asking for a waiver of it. And again, best of all, it does not require you to leave. So especially for those of you, especially for my parents of US citizens out there who have been here for 20 years, 30 years, you have adult children, but you know you have la barra permanente. Y otros abogados les han dicho que no hay posibilidad para arreglar. Este caso de visa T es una opción para usted, especialmente si ha tenido un jefe o una jefa que les han tratado muy malo durante su trabajo, ¿ok? Este caso puede ser una opción para usted. Y para agendar una cita, nuestro número es 212-248-7907. So if you have worked for a boss that has mistreated you in this way, please give us a call. Our telephone number is 212-248-7907. And if other attorneys have told you that there's no way for you to fix because you don't have a legal entry, you don't have an adult child, you don't have a spouse that you're married to that has status, then this may be an option for you, okay? And the only way to find out is to call to make an appointment, okay? So that is number one. Number two, we did have a question from one of our viewers last week who asked, if I do this case, will my employer find out that I filed for a T visa? Now, the very fact that you might be asking whether or not your boss will find out that you have filed for a T visa means that you are scared of your boss. And if you are scared of what your boss will do, then that is a very good sign to me already that this might be a good case for you. But let's go back to the issue. When you file for a T visa, we do have to report this thing that your boss has done to you to the Department of Labor or sometimes to the law enforcement agencies. However, your employer is not notified of you filing for the T visa. And most circumstances, the employer never finds out because nothing ever happens to the employer. However, I want you to consider the fact that if your employer owes you wages and they get penalized and they get forced to pay you back, then that is a double win for you, okay? Because that is definitely something that if it's possible, you should definitely pursue, okay? 212-248-7907. Okay, all right, guys, let's go ahead and see what questions I have today. Hello to all of my viewers. I had a question up here from The Wiz, from a client who's asking, I just learned about the Bonafide determination will be that it will be implemented for T visa applications. Do you know anything about it? Thanks, The Wiz. Yes. So the Bonafide determination is going to help people get a work permit while their T visa is pending. But the good news is that when you're applying for a T visa, the processing time of this case is about 1 year to 1.5 years. And this is pretty much the quickest processing time that we are seeing for within our immigration cases. It's much quicker than VAWA. It is definitely much quicker than a U visa. So the Bonafide determination is going to help persons get a work permit if the cap is reached. The good news is that for the T visa, the cap is not yet reached. If the cap gets reached this year or even next year, then they will start issuing work authorizations earlier, which is even great. But I actually haven't seen that go into that has not been implemented as of yet. But it will definitely help out people, and it should encourage even more people to apply for a T visa, okay? Hello, Chagall from Houston, from Tampa, Alex. Nice to see you all. Ziad, who's Lebanese, nice to meet you. Okay, can you please talk about the deferred action for Lebanese and how to apply for Ziad? Ziad, this is not something that I have done yet, so I would not be able to speak to it. Okay. Crypto Chain's asking, my lawyer did not file my VAWA concurrently. He only applied the I-360. It's already been 1.5 years. What do you think? Should I apply for the I-485 and the I65 or not from Crypto Chain? Crypto Chain, I wholeheartedly encourage people who qualify to file a concurrent I-360 and I-485 application to go ahead and do it. And for whatever reason, if your lawyer did not file the I-485 at that time and you are now eligible to file the I-485, then you should definitely do so. You can give our office a call, Crypto Chain, 212-248-7907. There's no reason you should be living for another 1.5 years without a work permit if you don't have to, okay? All right, let's see. Rebecca Z is asking, would my husband qualify for the PIP under Biden if he has a 10-year ban? From Rebecca. Rebecca Z, thank you for the question from TikTok. Rebecca, if your husband, there's two types of 10-year bars. There's the permanent 10-year bar, and then there's like the soft 10-year bar. If your husband has a soft 10-year bar, then the PIP may still be an option for him. But if he has the hard permanent bar of 10 years, because he crossed back and forth between the border more than once after 1997, then he could get PIP, he could get parole in place, but he would not be eligible for adjustment of status. And that's the green card. The green card is the golden ticket that we all want. So your husband may not qualify for the actual green card if he has the permanent bar through the Biden PIP. However, here are two other cases that we can look at for your husband where we could possibly fix the status even if he has a permanent bar. And that is going to be the T visa, which I just spoke about, that requires for him to have worked for somebody who was just a very, very toxic, bad boss, and also the U visa as well. Also, if your husband has a child, a U.S. citizen child who's 21, who has been basically a rebellious child, a disrespectful child, who has been hurtful to your husband, then he may also qualify for something called a parent DAWA. And in some cases, we can help fix the bar through that, okay? Marie, you're asking a question about our deposit. Our deposit's the deposit. We do require the full deposit to start because of certain issues that we've had of clients not paying us properly. So unfortunately, I do have to take a hard stance on that. But what I would say, Marie, is if you have that amount, just keep collecting, and we're going to stay in contact with you because we do want to help you with your case. It's just that we have to run things in a certain way for this law firm. So please don't give up on us either. How long does the T visa take from Lovely? Lovely, the T visa is taking, I would say, average 1.5 years. It's very quick. Sometimes we get decisions even less than that. Okay, let's see. What is the difference? Oh, Missy 189. This is a difficult question. What is the difference between final action date and filing date for a visa bulletin? Missy, I can't answer it straight because I always have to be looking at the visa bulletin to understand it. But final action date is usually one of the charts is used for applications for persons inside the U.S. The other chart is for persons who are not inside the U.S. I received 2 RFEs for my work permit in advance parole. Is this normal? Let's see. Sometimes it just depends. Sometimes we get RFEs for things that they need. Sometimes they say that things are missing when they're not. And sometimes situations change. But, we are responding to your RFE, and I'll make sure I take a look to see what's happening as well. Okay. Okay. If my siblings are here on TPS, can I apply for adjustment to status for them? If yes, how long would it take for them to get that? From John Zach. John Zach, great question. If your sibling is here in the US, can you help them get a green card? And the answer is usually no, because most siblings who are here are, number one, they're a sibling. And if you're a U.S. citizen, you have to file an I-130 for your sibling. And usually these applications will take more than 10 years to reach a priority date that is current. That means that if your sibling is here in the U.S., in order for them to be able to get a green card through you, they have to wait for your I-130 to basically be approved and to reach a priority date that is current. And then they need to be eligible to adjust status. And if your sibling falls out of status, if their visa is expired, if they accrue unlawful presence, and they're not in status when the priority date becomes current, then they are not going to be eligible for adjustment to status application. They would need to leave the U.S. to do consular processing instead. And sometimes that may be an option if they also have a parent or a spouse who's either a green card holder or a U.S. citizen through whom they can ask for a waiver through the I-601A. So in most cases, if you have a brother or a sister that you want to sponsor and they're already here, in most cases, it is a lot more complicated. That is why I encourage your brother or sister to get a consultation to see if they qualify for anything else that does not require sponsorship through you, such as a T visa, such as a U, and especially if they have been married to a U.S. citizen, but the marriage didn't work out. How many of you are out there who are in a marriage or who were recently in a marriage to a U.S. citizen or to a green card holder, and it did not work out? It did not work out because you guys were having lots of marital problems. They did not want to apply for you. Maybe they did apply for you and then they withdrew the application. They canceled the application, and maybe they just made your life extremely difficult. We did have a caller yesterday who had already started the process with her husband, but her husband was just making her life so difficult and miserable to the point where she is considering just giving up. If you're having those sort of marital problems where your husband or your wife is constantly putting you down, demeaning you, telling you that you're worthless, telling you that you're just an immigrant, telling you that you just married them for papers and that's why you're here. If they're telling you that you're just, you should go back to your country, or they constantly remind you, if your husband or wife constantly reminds you that they have control over your paperwork, that they have control over your process, and that basically you're here at their pleasure, that you are here because of them, that is simply not fair. That is not right. And when that happens to you, when you're suffering these sorts of emotional tortures and tensions in your marriage, it is usually a sign that your spouse is exerting their position as a US citizen with more power over you in your life. And as a result, it is considered to be manipulation. It is considered to be emotional abuse. It is considered to be an abuse of power. And when you're married to a US citizen that is doing this to you, then you may be eligible to file for a green card by yourself. You don't need to ask them for their help. You don't need to ask them for their permission. You do not need to ask them for their documents. How many of you have tried to file a case, but your spouse won't give you the tax documents? They won't sign off. They won't come to the lawyer's appointments. When you do a self-petition through VAWA, you do not need to worry about these things with your spouse. And it is going to give you so much freedom and power and control back over your own life, over your own destiny, so that you can take your immigration journey back into your own hands. It is hard enough to be an immigrant in this country with all of the hate that is out there, with all of the injustices and inequality that is out there when you're undocumented just because of your status. When you're in a marriage to a US citizen, you should not have to suffer a second time. You should not have to go through this misery a second time. You deserve love, you deserve respect, and you deserve to have freedom in your life, okay? And if you don't have that freedom, if you've been losing hope over what your situation is going to be, if you're afraid of getting deported, please call us at 212-248-7907. Is it possible to expedite the I-130 process from Blessed Beauty? Blessed Beauty, yes, it is, but you have to give immigration the valid reasons and documentation for your expedite. If my husband has a record, can he still fix papers? From Gloria Robles. Gloria, it depends on what your husband's charges are. Now, if any of you are trying to fix your papers, but you have any negative interaction with law enforcement, that means you were either arrested and then the charges were dropped, or you were arrested and the case was dismissed, or you pled down to a lesser charge, or you have a conviction of any other sort, you got probation, it got expunged. These are negative interactions with immigration that you must disclose on your application. And before you disclose it on the application, you need to talk about it with your immigration attorney, because everything needs to be analyzed. At my office, we try to be as careful as possible and make sure we analyze everything fully before we file for clients, because sometimes certain convictions or certain arrest histories may make you ineligible for cases, but other times you may actually still be able to fix even despite that. So Gloria, the only way to find out whether your husband qualifies is, number one, collect the paperwork. Go make sure your husband goes to the courthouses, to the police stations, wherever the arrest happened, and make sure he asks for the paperwork and the documentation about what the final charge was, because as lawyers, that's what we need to look at as the final outcome of the charge. Next, we need to analyze it to see if it's going to be a problem for the type of case that we want to do. And lastly, we need to pick the right type of case to do despite those charges, okay? So Gloria, I hope you'll get those paperworks done and give us a call, 212-248-7907. Thank you, Naila. Thank you for sharing my live. How many documents are needed per year for PIP? And what if you can't get a hold of everything, but you've been here from La Bambi? La Bambi, you don't need to get documents for every single day that you're here. But ideally, if you're trying to show 10 years of presence in the US, you want to get at least bare minimum something from every year. And then I would say bare minimum at least several months throughout the year. A perfect package will probably include one document at least for every single month of every single year, which is going to be a lot of paperwork. But you should try your best to satisfy that as much as possible. Spencer, thank you for the follow. And I don't do E2 visas. Oh, Maria. Maria says that her husband is waiting for his appointment in Juarez. He's got 2 DUIs. One was dismissed and the other is a class A misdemeanor from Maria. Maria, I hope your lawyer prepared your husband because Juarez is very difficult with DUIs. Depending on your husband's current drinking history and past drinking history, the doctors for the consul in Ciudad Juarez, they're pretty tough, and they're very quick to say that a person has an alcoholism problem. And if the doctors do say that for his medical exam, then unfortunately he's going to need a waiver, and he might need to wait longer in Mexico until that waiver process is okay. But I wish you best of luck. I hope everything goes well for his interview. I know it's very nerve-wracking and difficult when your family member is waiting. They've left the country for their appointment and they're waiting to come back and to see if they get approved. And that is precisely why in our law firm, we do our best to first try to see if our client is eligible for anything, any sort of case that does not require them to leave the US in order to get status, because we know the pain it causes to be separated from your families. We know the anxiety and fear it brings to leave the US, be away from your family, and face the possibility of getting denied. And we don't want people to go through that. I, as an attorney, I get so stressed out when any client has to leave the US. So I don't want to send any client out without first exploring all the options to see if there's anything we can do for the client without them having to leave, okay? So good luck, Maria G. Laura, America, my boyfriend has 18 years. If we marry, can we do a petition for me from Laura? Laura, America, Laura, if your boyfriend is a U.S. citizen, you get married, he might be able to petition for you. It depends on, number one, how you entered the U.S. Immigration law makes it very, very difficult for people to fix your status, especially if they entered the U.S. illegally. And if that's the case, then we can still explore some options for you, okay? So Laura, give us a call, 212-248-7907. Marie, thank you for sharing. Sunny is saying, my I360 got approved. I went to my I485 interview, and I still don't have a response from Sunny. So Sunny, I know that's frustrating. When you go for your I485 interview, even after your I360 is approved, number one, please don't go to your interviews alone. Please don't go to your interviews alone. If you can help it, please don't go to your immigration interviews alone, because officers try to pull ish all the time, okay? Please do not go to your immigration interview alone. Officers don't have your best interest at heart, okay? Let's just get it straight. Officers, there are some officers whose mission it is to try to deny you no matter what. So do not go to your immigration interview alone if you're applying for a green card. And even then, there's some clients, like if you're going for your citizenship interview, you should also not do that alone, okay? I don't recommend it. If you can afford an attorney, please take an attorney with you. And if you can afford and have the ability to find an attorney that you trust, who you know has experience, who you know is gonna fight for you, get that attorney, okay? At my office, we do go to we try to go to every interview with our clients unless there's a huge conflict that we can't accommodate. But I don't like to send clients alone. And we have an amazing legal team of, right now we're 4 attorneys besides me. So we are here for our clients. But if you went to your I485 interview and it did not go the way that you thought, what can you do, right? What can you do to fix the situation? And what's normal? What's normal in order to expect a decision? How much longer will you have to wait to get an approval or a denial, right? So number one, when you have your interview for immigration, it is actually not abnormal for it to take several months to get a decision. Typically, the majority of people will get a decision right away within less than 30 days. But I have had plenty of cases where we have had to wait several months for an interview, but that is not the norm. And when it comes to an I-360 interview, you have to be very careful what they ask you and what you respond, because sometimes they're looking for inconsistencies in what you say. And if it takes a long time after you have your interview until you get a decision, it is usually because you may have said something at the interview that is not consistent with what was written in your application, and they might be sending it back for a further inspection of your case. But hopefully it's nothing more than that. Sometimes the delay can also be because the officer is backed up. Sometimes a delay in a decision after your interview may be because you have a criminal issue or some other immigration issue that requires a double check and an approval by a supervisor, okay? So even if you had your interview for an I-485 and it's taken a few months, it's not abnormal. But if it takes more than 3 or 4 months, then you should call, make a little bit of noise, call customer service. You can do inquiries, you can do a lot of things to get your case pushed through, okay? How much time does it take to get a green card through VAWA? From Krishan, it takes about 3.5 years. Alicia, if your social security gets lost, then you need to go to the social security office and apply for a replacement. It's not too difficult, but it will take a little bit extra work on your part. How long does it take to get a green card if you're married to an American citizen? Well, if you do a joint case and your spouse is sponsoring you, then it can take anywhere between 6 months to 1.5 years to get your green card. In Nigeria, our consultation fee is $150. Do you work with veterans and veterans' families? Of course we do, Tavares. We do. I'm a naturalized citizen and my wife is on F1 visa. How long will it take? From Anuraj. If your wife has no other problems, then probably take anywhere from 6 months to 1.5 years. Does immigration forgive assault to a family member from 2010 from Erica on TikTok? Erica, so if there's an assault on a family member, then that's probably domestic violence related, and that can be very tricky. Now, if you have any sort of domestic violence conviction in immigration law, then this is definitely an additional layer of complication. And you need to get your documents analyzed by a good immigration attorney who understands how to analyze these documents to see what the immigration consequences are of your assault to a family member. So Erica, feel free to get that documentation together and give us a call, okay? Now, it doesn't always, let's say, here's something I do want to tell you about. If you are in an abusive marriage or a toxic marriage and you and your spouse are fighting constantly, or if your spouse calls the police on you, or you do get a conviction because you're defending yourself against your spouse, when you file for a self-petition through VAWA, we can usually ask for a perdón or a waiver of that charge, especially if it's connected to your spouse's abusive, toxic behavior. So it's not always going to foreclose your possibilities to fix, okay? But the circumstance has to be right and the conviction has to be analyzed. Okay, Erica, you can give us a call, 212-248-7907. I got granted asylum by an immigration judge, and do I need a work permit to work legally? From Keenan. When you get approved for asylum through court, then they don't always send you a work permit, but you might want to have a work permit because it's going to make your life easier. So I would recommend that you apply. Yes. Singh, nice to see you. My brother has a pending case through my mom, who's a green card holder. It's been about 7 years, and we're always confused. Missy, I'm confused too, because if your mom's a green card holder, then that means that your brother is probably, I don't know, a minor. I'm not too sure what it is. Can you expedite a VAWA application? Yes, if you have compelling circumstances and reasons and proof, then you can ask for an expedite. Are they doing a waiver of interviews? Sometimes they do, sometimes they still ask you to come. Do you have to be married if you want to become a citizen with permanent residency already? No, there's multiple cases that may help you get a green card even without marriage to a spouse. But the only way to find out is to see if you qualify is to go through the questions. From Yancy on YouTube, after the I-130 is approved, how long does it take for the I-485 to be approved? When filed concurrently as a parent of a U.S. citizen, are both forms processed together at the same office? From Yancy or Jency. Yancy, that's a good question. If you file a concurrent I-130 and I-485, typically these are processed together at the same location. And if it's a parent case, they usually process them without an interview, but sometimes you will still get an interview. But if they happen to decide one before the other, I don't know why they would, but sometimes, I don't know, you never know, I guess. The I-130s typically take about a year to a year and a half, and an I-485 can take 3 months to a year for an interview if they give you an interview, okay? So good luck, Yancy. Is it true that my spouse, who's a non-resident, can apply for an ITIN and then we apply for a green card later and she can still be eligible for SSN? Tax preparer said it's possible. So Zay, if you are a citizen or a green card holder and you're applying for your spouse, anyone can have an ITIN number if they don't have a social security number. But just because you have an ITIN number, it doesn't mean that you can't get a social security number later. As long as you're eligible for a social security number and you apply for it, even if you have an ITIN, you'll still get a social security number and it will be a different number. So it is possible, yes. You're welcome, Zay. Andrew, after a fingerprint, what is the next step for a T visa? After a fingerprint, Andrew, it's just a matter of waiting. You just have to wait. Sometimes you have to wait, 6 months to a year, and maybe you'll get an RFE or maybe you'll get a decision. Think Big 91. I have an approved I-130 through marriage, but my now ex-husband does not want to continue with the paperwork. Do I have a priority date, or do I have a possibility? From Think Big. Think Big, this is a great question and a very difficult situation to be in. If you have an I-130 that was filed for you by your spouse and it was approved, but they don't want to continue with the process, what options do you have? And the option can be that you may qualify to do a self-petition instead to continue your green card process without your spouse. Now, typically, after entering into marriage, and even, by the time your I-130 is approved, that means, I have a question about why your spouse didn't help you file an I-485 at the same time as an I-130. And I do have to tell you the truth that a lot of times when I see that a person is eligible to file as a spouse of a U.S. citizen, but they only file the I-130, to me, sometimes there might be a valid reason for it, but if there's no good reason for it and your spouse only files an I-130 for you, that means they're not 100% committed to your process and they still don't want to go all in on helping you file for a green card. So that's a red flag number one. Red flag number two, they don't want to continue. That's because they now know that they don't really have any excuse to not help you, right? And when that happens, when your spouse wants to pull the support after being married, after promising you that they're going to help you, after promising you that you're going to have a life together, and probably telling you on multiple occasions that you owe them for their help, that you owe them for their support, and they use that as an excuse to treat you like crap, then those are usually signs that you should explore the option of filing a self-petition. And when you file a self-petition, you remove that stress. You remove that basically, you're living your life according to your husband's whims, right? You're living your life stepping 1 foot at a time, not knowing when they're going to blow up. You're walking on eggshells. You're afraid, they constantly tell you that you're going to get divorced. You're doing your best to keep them happy, but it's causing you anxiety and depression and fear. Maybe they're putting their hands on you or making you do things that you don't want to do. all because they say that you owe them because you're being helped for because of your papers. Those are situations that I want you to consider the possibility that you don't have to put up with that, and you may be able to apply by yourself, okay? And we would love to help you file. We would love to be the law firm to help you get out of that situation and take control back into your own hands, okay? You can give us a call, 212-248-7907. Can you help with an alien smuggling ban from Selma? Selma, the waivers for that are very narrow and we don't work on those. If you file a VAWA, what time do you submit your medical? We usually wait for an RFE for that because it might expire by the time they get it, okay? All right, everybody. I hope everybody got some value and some good information out of this live. Again, one thing that I do want to stress to you is that if you're undocumented and you have not yet explored your options or you're waiting, you're still not sure what to do, please take action, get your applications filed. Time is always of the essence because every day that you wait to not file your case is another day that you're losing to anxiety and fear, and you deserve to be safe. You deserve to be loved, and you also deserve respect and freedom, okay? My name is Moumita Rahman. Our telephone number is 212-248-7907. If you wish to schedule an appointment, call us. This is our only number. Don't fall prey to the scammers and imposters that are out there. This is our only telephone number, 212-248-7907. I hope you all have a wonderful day, and God bless. Good night.